And we're back on page 69, Alternative Dispute Resolution, commonly known ADR. Talked about it a little bit in our first class, but alternative dispute resolution ranges from a variety of things to very common elements of negotiation, all the way to international arbitration commissions deciding huge world events and huge international commercial dealings. But to begin with, we'll talk about the little ones like negotiation, something that a lot of us, especially individuals who are business owners, deal with probably on a day-to-day basis, and maybe a lot of times even in our own families we deal with negotiations. Alternative dispute resolution. So let's read a little bit from the book. Litigation, the process of resolving a dispute through a court system, is expensive and time-consuming. Litigating even the simplest complaint is costly because of the backlog of cases pending in many courts. Several years may pass before cases are actually tried. For these and other reasons, more and more business persons are turning to alternative dispute resolution, ADR, as a means of settling dispute. So litigation, the act of arguing a case inside of a court system. The book notes it can be costly and time-consuming. It's true. We actually have a term called paper judgment in the attorney world. A paper judgment is basically, yes, for example, if you have a business agreement and somebody owes you money, the court may agree with you. But just because the court agrees with you doesn't mean you're getting your money. The individual may not have any money left. The individual may declare bankruptcy. The individual may have even sold off the property he bought from you if you're dealing with a property issue. So sometimes, yes, you're right, but it doesn't mean you're getting any money or anything in return. And that's always a difficult item, especially if you have to pay for an attorney, because not only did you lose the money, you also have to pay the attorney that you hired to help you sue. So very good attorneys will often advise their clients, I'm sorry, you should just go ahead and try to settle this dispute without filing a lawsuit. Because if you do, you may win, but you may not get anything in return. Hopefully, at least this way, you can get something if you negotiate or you mediate the items before actually costing yourself a lot of money. The book notes the great advantage of ADR is flexibility. Like we'll see, the book talks about various types of ways of dealing with a dispute. This is alternative dispute resolution. This is the frontier of breaking from the static model of I'm going to sue you. This is solving elements on their most basic level to their most complex level using alternative means. The book breaks down some elements for concept summary. That's from before. I want you to look at that before. But let's talk about negotiation on page 70. Negotiation is the simplest form of ADR. If you eat all of your dinner, I will let you have dessert. That's basic negotiation on a family level. If you do this, I will let you do this. How about if I have half of my dinner and you give me just half of a dessert? That's your child then trying to negotiate his way into some dessert. That's how it works. Negotiation is just the interaction of two people coming to an agreement, a coming together of minds. Negotiation is basic, simple. This is what we're working toward. Let the two of us just come together and see if we can hash this thing out. The next the book talks about is mediation. In mediation, a neutral third party acts as a mediator and works with both sides in a dispute to facilitate a resolution. The mediator normally talks with the parties separately as well as jointly, emphasizes the points of agreement, and helps the parties evaluate their options. Although the mediator may propose a solution called the mediator's proposal, he or she does not make a decision resolving the matter. The mediator, who need not be a lawyer, usually charges a fee for his or her services, which can be split between the parties. States that require parties to undergo an ADR before trial often offer mediation as one of the ADR options, or as in Florida, it's extremely popular, is the only option. Florida really highlights ADR, alternative dispute resolution, especially in family law cases where you have a divorce going on. Florida sometimes mandates mediation. You have to go through mediation before you can even step into a courtroom to have the judge decide your case. Now, mediation works on a basic level. The mediator doesn't get to decide this is what you will agree with. The mediator is there to help you negotiate an idea. Sometimes people can't face each other. Let's say they're disputing a contract or something like that, and they don't want to deal with the other party. The mediator acts as the middleman. He's the one who works back and forth in between the parties to help them resolve a situation. But at the end of the day, it's still the two parties that have to agree. The mediator is just basically the bridge. They have the term, don't shoot the messenger. He is the mediator. He's not the one giving you the ideas. He is simply helping you get an idea to where you want to be and where you're comfortable making an agreement. Sometimes it helps by having somebody in the middle when negotiations break down. But I'm going to say it again. The mediator does not make the decisions for you. If you don't want to follow through, the party just simply steps away. Book notes, one of the biggest advantages of mediation is that it is less adversarial in nature than litigation. In mediation, the mediator takes an active role and attempts to bring the parties together so that they can come to a mutually satisfactory resolution. Next, we have arbitration. Arbitration is a more formal method of alternative dispute resolution in which the arbitrator, a neutral third party or panel of experts, hears a dispute and imposes a resolution on the parties. Arbitration, the arbiter makes a decision for you. He hears what's going on, and then he says, all right, this is my decision. This is what you should do. That is different than mediation, where the two parties still have to agree. In arbitration, whoever is appointed, the neutral third party or a panel of experts, they're the ones who make the final decision. They're the ones who say, this is how it's going to work out, and you have to abide by that decision. This is extremely popular now in commercial settings where you agree to arbitration, where you won't sue, but you'll agree to have a neutral third party or a panel of experts make up your decision. A lot of those contracts that I basically told you when you sign up for example, getting an email with Gmail, when you get iTunes and they have those long things, do I agree with this? Yes, I agree. Click to agree. Nobody ever reads any of those things. A lot of those have mandatory arbitration clauses, meaning if you have a problem with iTunes, Apple, Google, you've already agreed to arbitrate your case. You have not agreed to basically be able to sue. You signed a contract saying, I agree to arbitration. Now, in the grand scheme of things, sometimes this can be sued over and people can get out of those decisions, but it still holds true where the contract, it's something you agreed to, and sometimes you can't avoid going to arbitration. The arbitration process. In some respects, the formal arbitration resembles a trial, although usually the procedural rules are much less restrictive than those governing litigation. In a typical arbitration, the parties present opening arguments, ask for specific remedies. Evidence is then presented, and witnesses may be called upon and examined by both sides. The arbitrator then renders a decision called an award. An arbitrator's award is usually the final word on the matter. Although the parties may appeal an arbitrator's decision, a court's review of the decision will be much more restricted in scope than an appellate court's review of the trial court's decision. The general view is because the parties were free to frame the issues and set the powers of the arbitrator at the outset, they cannot complain about the results. It makes sense. You agree to go through the process, then how at the end of the day, when it doesn't go your way, of course you're going to agree to try to get out of it. But no, you agreed in the first place to submit to arbitration. You should abide by the arbitrator's decision. The arbitration clauses and statutes. Almost any commercial matter can be submitted to arbitration. Frequently, parties include an arbitration clause in a contract. That's exactly what I'm saying. Most agreements, they call it boilerplate, but all those languages inside those contracts that you sign, credit card agreements that have all those tiny paragraphs and tiny writing, one of those clauses is usually an arbitration clause. Why do they have it in there? Because it saves the company's money. Instead of having to fight out a suit, they can say, no, you agreed, you can't sue, we have to go to arbitration. The issue of arbitrality. When a dispute arises as to whether the parties to a contract with an arbitration clause have agreed to submit a particular matter to arbitration, one party may file a lawsuit to compel arbitration. The court before which the suit brought will decide not the basic controversy, but rather the issue of arbitrability. That is, whether the matter is one that must be resolved through arbitration. If the court finds the subject matter in the controversy is covered by the agreement to arbitrate, then a party may be compelled to arbitrate the dispute. That's exactly what I'm talking about. Sometimes you can challenge the arbitration clauses. Doesn't mean you'll win, doesn't mean you get to argue before the court, but the court can make a decision to find out, is this issue really up for arbitration? Mandatory arbitration in the employment context. I'm on page 74 now in the book. I want you to look in this section very clearly. I talked about at the end of the school year, you guys were presenting a case before me and before some of my lawyer friends. I have a feeling it's going to be an employment law. So make sure to read this section, mandatory arbitration in the employment context. It'll be extremely important as we go later on. Now the book notes and some other elements, other types of alternative dispute resolution. The three forms of ADR just discussed are the oldest and traditionally most commonly used forms. As mentioned earlier, a variety of new types of ADR have emerged in recent years. The first one's early neutral case evaluation. The parties select a neutral third party, generally an expert in the subject matter, to evaluate the respective positions. The parties explain their positions, the case, and then the case evaluator assesses the strengths and weaknesses of the parties' claims. Why is that important? You actually pay somebody to look if you have a case. Hey, if we submitted this to arbitration or mediation, how would this end up? And the person says, well, this is how it would end up. And then based on that decision, we're like, okay, well, maybe I'll go through with it. Maybe we won't go through with arbitration. We have a mini trial. Each party attorney briefly argues the party's case before the other, and a panel of representatives from each side who have the authority to settle the dispute. Typically, a neutral third party acts as an advisor. If the parties fail to reach an agreement, the advisor renders an opinion as to how a court would decide the issue. And then numerous federal courts now hold summary jury trials, in which the parties present their arguments and evidence, and the jury renders a verdict. The jury's verdict is not binding, but it does act as a guide to both sides in reaching an agreement during the mandatory negotiations that immediately follows. Other alternatives being employed by courts include summary procedures for commercial litigation and the appointment of special masters to assist judges in complex issues. Book also notes about the American Arbitration Association. It's basically some companies or some groups actually offer arbitration as their form of doing business. The final element is online dispute resolution, ODR. An increasing number of companies and organizations are offering dispute resolution services using the internet. The settlement of disputes in these online forms is known as ODR. The disputes resolved in these forms have most commonly involved rights to domain names, website addresses, or the quality of goods sold via the internet, including goods sold through internet auction sites. ODR may be the best for resolving small to medium-sized business liability claims, which may or may not be worth expensive litigation or traditional ADR methods. So alternative dispute resolution is about breaking the mold of our general realized sort of system of our court system, where you prepare a complaint, you sue the person, because, as the book mentioned, suing something can be really, really expensive. For example, let's say somebody owes you $2,000. You want to hire an attorney, you want to sue that person. Well, that attorney may end up costing you $2,000. You win the case, all that money goes straight to the attorney. That's a problem. Now, sometimes you get to sue for attorney's fees as well, where not only you get the money, but you also ask for attorney's fees. But it doesn't mean the court has to grant it at the end of the day. You also have things to worry about paper judgment, as we talked about before. Alternative dispute resolution is meant as a break from these elements, where you sit down, you decide, how are we going to work this out? Let's make this happen. Sometimes you can't. Sometimes no matter how hard you try, the person on the other side doesn't want to come to an agreement. In those elements, then you have to go about and file a criminal or civil litigation, take this person into court. Now, the rest of this chapter focuses on questions and case problems. These are the items that we will be going over in class together as we work through it. I've included these videos on your part to make sure that you go through all of them. You can go back or review other ones. But right now, we're done. This is the last video of me talking. Make sure to look at the items that I placed on ingrade.com. We'll be talking about those as well in our next week of class. But thank you very much. Like I said, this is a brand new future of education, hopefully. You know, we're exploring new realms together. Hopefully these videos helped you. You were able to view them at your own time. And then when we come into class, you'll be well prepared. Like I said, make sure to read through Chapter 3. Write down some notes on the items that are talked about in the case sections at the end of Chapter 3. But that's it, folks, and I'll be seeing you in class. Thank you very much.